Hello everyone, I'm Arnie Clarke. I'm a UK and European patent attorney and partner at Gill Jennings Every. We're a specialist IP firm with offices in London and Munich. Welcome back to part two of our introductory talk to oppositions at the EPO. So in terms of timescales, I'll go into this in a little bit more detail. This is just to give you an oversight of the procedure. It used to be that oppositions ran to sometimes several years, a few to decades. In recent years, the last couple of years, the EPO has brought in procedures which mean that they aim to get oppositions heard within 16 months of the opposition deadline. That's through to a first instance hearing. And I'm really pleased to say that they seem to be sticking to that, that time scale. So you can actually get a reasoned decision within a reasonable period of time. So what are the preliminary considerations for deciding whether you want to file an opposition? I think it's fairly important to establish what your objectives are as a business and to make sure that they align with your business plan. Obviously, it depends on the size of your business and how much interaction you have with that overall strategy. And it makes that decision easier or harder. But I think it is important to review this in the context of what the business is trying to achieve, and not go into the opposition procedure lightly. Once you've established what your objectives are, then you have some choices and you need to decide whether the objectives that you've set out are actually achievable. So as I mentioned earlier, often the objective is total destruction. You want to completely get rid of a patent right because you want to operate in that area along with the rest of the world if you manage to destroy that patent right. Sometimes you just want to narrow the scope for the reasons I mentioned earlier, hopefully keeping you, giving you freedom to operate, but keeping your competitors out. That's not always possible, but it's a reasonable aim. And a question that a lot of people, I don't think, ask enough is whether they should file an opposition at all. Is there a reasonable workaround, for example? And even if that's not your primary strategy, maybe it should be, you should be working on that as a contingency. Similarly, is all you need a declaration of non-infringement? That can be relatively cheap and easy to get. You're going to have to do that on a national level, but nevertheless, you might have a very good non-infringement argument. Again, if that's not your primary outcome that you want, because it really is a 50-50 situation, it can at least be a secondary aim that you're looking to get that non-infringement opinion, as well as challenging the validity of the patent and hopefully making that non-infringement opinion easier to achieve in the long run. Sometimes it's just better to negotiate, establish whether you're going to achieve any of your aims, whether the patent's weak or strong, and sometimes you're just going to have to accept that it's bulletproof and you're going to have to negotiate. So a license or to buy the patent rights. But it is worth working that out before you really upset everybody on the other side and then ask for a license after you've put them all to great expense and effort. And then, of course, you need to check whether those aims and objectives are achievable in the timescale that we just looked at. So remember, you've got about 16 months from filing the opposition. There is an appeal procedure as well, which is going to add a couple of years onto the end, and quite a number of cases do go to appeal. Are you going to be able to achieve what you want in that timescale? Sometimes you can't. Sometimes it's fairly easy. In fact, if I go back to this figure here, sometimes you'll find that this 4-month period on the left-hand side of the screen, when the when the patentee responds to the opposition, you might find that they file a set of claims which gives you your freedom to operate, at which point perhaps it's time to talk to them and say, okay, well, if you maintain that, I'll not continue the opposition because I've got what I want, you've got what you want, which is, you know, a restricted scope, but that still gives you some protection. So perhaps you'll get a very, very quick answer after filing an opposition within a short time scale. So it is achievable. So I think another key aspect that people don't always think through at the beginning of these procedures is what grounds of oppositions can be supported. Now, I mean that from the perspective of, are you creating a legal conflict elsewhere, or do they cut across other patent rights? By rubbishing the opposed patent, you might also be rubbishing your own patents if you also have IP yourself. So what can you say that's going to damage them but not damage you? I'm constantly battling, unfortunately, with US attorneys as to what I can and can't say in opposition, but I completely understand why there are times when I can't say things that are going to create a problem in, for example, parallel US litigation. So you do need to work that out beforehand. And then what evidence do you need in order to support the grounds of opposition that you're going to use? Now, one of the big issues that I often face is I get clients turning up and saying, we haven't got a novelty knockout. Our bit of prior art is just not that close. And well, there are other games in town. If you look at the revocation statistics that the EPO publishes in its annual report, you'll see that the number of cases revoked for lack of novelty is just 13%. So there are a number of other grounds of opposition. I say notably the added subject matter, that's Article 1232 for those of you who are familiar with the EPC. 20% of cases are revoked for added subject matter violations, and over 50%, about 52% are revoked for lack of inventive step. So there are other grounds that you can use other than just novelty. So don't worry if you haven't got a novelty knockout. There are other games in town. Do you need to carry out further searches? I think one thing that is pretty important, I would say, is give the examiner, the opposition division examiner, something new to think about. If all you're doing is presenting prior art and arguments that he considered or she considered during examination of the case, it's going to be difficult to sway them to revoke the patent on that basis. So be prepared to carry out some additional searching if possible. The EPO likes written evidence, clearly documented, published evidence to support an opposition. So provide that wherever you can. Now, prior use evidence, that's something the EPO won't have. So that'll be something that's maybe carried out in, that you're aware of, maybe in your factory or your lab or wherever it is, that the EPO couldn't possibly know about. You may be able to support your case with that prior use evidence. It can be very tricky to do that. It has a very high burden of proof associated with it, but it does work if you set your case up correctly in the first place and make sure that you have ticked all the boxes required to meet the standards set by the EPO. And then do you use expert testimony? I'll come on to that in a bit more detail later, but certainly you can use experts to support your case. It's not always a good idea, and it's not always a good idea for everything that you might otherwise use them for in national litigation. The EPO tends to like factual rather than opinion-based evidence, so it will like it if an expert says this is what this particular document or this is what this particular technical teaching means. It will not like it if your expert rocks up and tells them that the invention is obvious. So think twice about that. And of course, it adds significant burden in terms of cost to running the opposition as well if you've got an expert in tow for the whole process. I'd say once you've got all of those things together, have a preliminary assessment and check that it aligns with the business plan again. Can you actually support your opposition in a way that actually supports the objectives of the business? If you can't, then go back and look at the alternatives, the negotiation, the declaration of non-infringement routes that you might take if you're not going to get what you want by filing the opposition, or at least again have them as a fallback. So very briefly on this, because this is kind of more my job side of things, is what does the EPO like? Well, it needs a written statement in terms of the opposition. It prefers written, clearly documented technical evidence. It's not going to want hearsay of someone in a field who saw a combine harvester doing something that fell within the scope of a patent at some point. It's going to want a photo of that, and preferably it written up in a contemporaneous document somewhere. And as I said earlier, rely less on expert evidence because it's a bit more cost effective, and if you do that, if you can get away without having to use experts. And prior use is a very high burden of proof is required. The EPO refers to it, they used to refer to it as being up to the hilt evidence. That's essentially beyond any reasonable doubt. So you need to make sure that if you are using prior use evidence, everything is documented. Any proof that you have in terms of documentation is great. Get testimony from any people who saw the prior use taking place. So it's, what happened, when did it happen, who saw it, what have you got to actually prove that occurred, will all need to be shown if you to stand any chance of using prior use evidence. I say if you are basing your opposition on prior use, then make sure you've got a plan B, because it is someone will on the other side will try and pick holes in that, often successfully, I'm afraid. So you then, once you've filed your opposition, you go into a written phase. If I can go back to this timescale, we're now on the left side of this picture. There's a month period, it's not really a month, it's often even less than that, where the EPO will look at what you have filed and check that it complies with certain fairly basic formal requirements. Is there a written statement? Have you paid the fee? Things like that. And once they've checked that, it will go out to the patentee, and the patentee is invited to reply within 4 months and to submit arguments and or amendments in response. And a patentee at that point will often file, well, they have to file a main request unless they're abandoning their case. The main request is just what they want out of this procedure, which is often the claims as granted, but they can file an amended main request at this stage, and they often file auxiliary requests, which are fallback positions. I'm sure most of you are aware of what an auxiliary request is. Fallback positions, if I can't have my main request, I want this, and if I can't have this request, I want the one below it. And the opposition procedure is fairly flexible in that regard. One thing I would say is, as an opponent, jump all over the patentee's response at this point. As soon as the patentee's response is in, the EPO usually starts to weigh up the merits of the opposition and what the patentee has said. My view is that I would like them to hear what I've got to say, the EPO, when they are coming to that preliminary opinion about the merits of the opposition. So be ready when that response goes in to the EPO. You might need to provide some data to support it, further evidence. You might need to address the auxiliary requests that have gone in at that point. And it's an opportunity to worm your way into the other side's case. If they have submitted some amendments at that point, most of you will be aware that sometimes it's really difficult to amend a claim without infringing the added subject matter requirements. Even if you're an experienced practitioner, sometimes it's impossible or near impossible. So if they've amended their case at that point, it's an opportunity for you to perhaps extend the grounds of your initial opposition to grounds, or at least arguments, which did not bear on the claims as granted. So absolutely, run riot with that and make sure that you get in, I think, a timely response, which will help form the opposition division's preliminary opinion. That preliminary opinion will be generated and sent out with the summons to oral proceedings, which usually comes out a few months after the patentee has provided its response. And with that, you get this preliminary opinion, which is, as I say, the opposition division's take on the merits of the case. Again, jump all over that. Don't sit back and wait until you get to a hearing. If it's negative for you at that point, what can you do? Can you come up with some more data, some more evidence? Have they misunderstood your arguments? Can you correct them? Because the sooner you can do that and get the opposition division on side before a hearing, the less likely they are to be fixed in their mindset when you get there. So you can continuously try to steer them around to your way of thinking throughout this procedure. And then the written procedure comes to an end, usually 2 months, or now it's always 2 months before a hearing. That's the point at which you're not, well, of course you can submit things at any point during the procedure, but it's the last point at which the opposition division's obliged to consider them. So again, I would say if you have something to say, try and say it before then if you can. I think the procedural games that used to be used frequently ran things right up to the deadline and right up to the hearing. The EPO is getting tired of that, I would suggest. And I think you've got a better prospect of a good outcome if you try and persuade the opposition division ahead of time, especially with these shorter deadlines that they're working to of 16 months. So I was about to say, who are you up against? Of course, you're up against the other side, the patentee in this case. Sometimes it does feel as though you're up against the opposition division. That might sound a little uncharitable, but what you have to remember is that often the primary examiner in the opposition is the same examiner who handled the case during the pre-grant examination phase. Now, for the most part, I've found them to be completely unbiased, of course, and will be open-minded about the objections that you raise. On occasion, I must confess, I felt as though I've been having the argument with a member of the opposition division rather than with the patentee. I think there is a bit of, understandably, some pride involved in having granted a case which now might look a bit ragged once you filed an opposition against it. Just bear that in mind. Be kind, persuasive, don't make them feel stupid. Often if you present them with some new arguments, some new data, some new documents and evidence, and you're just careful with their pride, that can go a long way to getting them to change their mind in your favour. The other thing to note, I'm sure many of you are aware, the members of the opposition division are experienced, qualified judges. They will have a background in, even if it's a general background in the technical area that you're dealing with. It's also worth remembering that they don't know everything. It's all very well having a background in biochemistry, but you're unlikely to know the clinical practice of a multiple sclerosis doctor, for example, which might be the specific area of art that you're dealing with. So sometimes you do actually have to teach them aspects of the case and the common general knowledge. As I say, just try and do that gently and don't make them feel stupid. And if you're not getting anywhere with that examiner, you'll see that in the hearing often. Sometimes they just close down. Remember, you've got 2 remaining members to persuade as well. It's a majority decision, and the other 2 members of the opposition division won't have had any previous involvement in the case. So if you're getting nowhere with one of them, focus on the others. I've often seen that work. You can often see it actually in the hearing themselves. They might be bickering amongst themselves, and you can really focus on the ones who seem to be on your side. Very briefly, the EPO does not like late filed evidence. If you're an opponent, that pretty much means anything after the opposition deadline's closed, or anything in response to what the patentee has said in response to the opposition. It works both ways, of course, and from an opponent perspective, that can work pretty well. So I would say if the patentee is submitting late arguments, documents, auxiliary requests, lots of auxiliary requests often come in from patentees, complain about it. Do it constructively, but complain about late amendments, complain about excessive and late requests. Are the requests converging? They're supposed to, you're not supposed to dot around auxiliary requests to lots of different inventions that fell within the scope of the original claims. they're supposed to be converging in the sense that they apply to the same or have the same inventive concepts associated with them. Request extensions, request postponement of the hearing, request 2-day hearings. Now, you won't often get them, but I think what it does is it puts pressure on the EPO to give less leeway to the patentee. So at some point, the patentee is going to run out of chances to amend its case or to put in further evidence. If you can make it difficult for them by making it easy for the EPO to say, actually, look, we need to be fair to both sides here. We've only got a 1-day hearing. We can't hear 70 auxiliary requests that were filed at the last minute in that 1 day. It might be that you can limit the ability of the patentee to operate effectively and to get something out of that they want. And that happens all the time. So next thing, you're going to turn up to oral proceedings, the hearing. That's usually no longer than a day. Often, one thing I didn't mention, you can have multiple opponents. I've been in a hearing with 15 opponents against one patentee. Those generally are scheduled for more than 1 day, but if it's a relatively simple opposition with a limited number of opponents, they'll hear it on 1 day. As I just mentioned, tactically, if you press for longer than 1 day, the EPO often won't give it to you, but it might pressure them to keep certain evidence, amendments, etc., out that the patentee might try to submit. Increasingly, these hearings are being heard by video link. Now, what do I feel about video links? I think there's nothing better than being actually in front of an opposition division and the other side and being able to see what's going on, see how they're reacting. I think you can learn an awful lot from the body language and how people are behaving during the hearings, which you don't get with a video link. I'm also very conscious that I think it's amazing that the EPO have actually managed to organise a video link system so quickly and effectively, and it is an effective system. I think that justice delayed is justice denied. So the fact that these hearings can go ahead, I think, is a good thing, and of course is going to prevent a massive backlog in the future. So don't be afraid of using video links if it's in your interest to get the hearing heard quickly. I think they work well. I've had a few of them, and yeah, well, I won, so they can't be too bad. I'll start complaining once I start losing, I'm sure. But yes, they're a good thing, I think. Both parties have an opportunity to be heard at the hearing, usually opponent first, and then the patentee will mount its defence. And it's also obviously the last opportunity to make arguments and any requests that you have before the opposition division take a decision. Try to say something new, or at least don't regurgitate verbatim the written arguments. The EPO will have read the case. Try to have a dialogue with them, try to engage with them, try to look them in the eye, as you know, it's basic advocacy really, and try to see how they're reacting to your arguments. You know, polish the good bits more, and try and get over your best arguments, and obviously paper over the bad bits if there are any. And also, how are you going to deal with the main and auxiliary requests? At the hearing, one thing people forget is, can you negotiate during the hearing? I've been in a few cases where you can actually, if you find you're getting somewhere as an opponent, I've certainly had approaches which say, okay, stop here, and we will make this our main request. So the patentee goes home with what they want, and you get what you want. So don't be afraid to have those, or be prepared to authorise those sorts of discussions during a hearing. Just because you're getting somewhere as a opponent doesn't mean that you should automatically try and destroy the case if you might get something out of it by just being amended. So bear that in mind. You'll get a decision at the end of your hearing. It won't always be reasoned. Sometimes you can glean something out of it, but often it will be, you know, the case is revoked or maintained as amended, fairly straightforward. And that will be followed up usually within a couple of months. Sometimes it can take longer, with a full written decision. That written decision sets the clock ticking on. I won't be discussing appeals today. That is a completely different kettle of fish, and we might talk about that next year. But obviously, any party that's been disadvantaged by the decision, and that can be one or both, can file an appeal. So be prepared to deal with that. Thank you. That brings us to the end of this second video. Do join us for part 3, where I'll be discussing some hints and tips as to how you can help your patent attorney to run the opposition procedure to your benefit.